Ever get that feeling? You know that one where someone throws a contract your way and you're like, whoa, I'm in over my head. Happens to the best of us, really. But what if I told you there's this whole other side to contract law? A place where it's less about the hard and fast rules and more about navigating the, shall we say, the dance of real-world business. Well, that's exactly where we're headed in this deep dive. We're going deep into the world of relational contracts, uncovering those hidden clauses and implied terms that can make or break a deal. And to guide us through this maze, we've got our expert on the subject ready to jump in.
Absolutely. Let's unravel this fascinating world together.
So first things first, relational contracts. It's a bit of a mouthful. What exactly are we talking about here?
Right. Well, unlike your typical, one and done transactions, buying a coffee, that sort of thing, relational contracts, they're built for the long haul. Think big ongoing collaborations where flexibility is key. We're talking long-term supply agreements, those big franchise deals, even those complex employment relationships that keep businesses humming.
Okay, so picture those huge long-term deals, things constantly in motion. I can see how a rigid by-the-book contract wouldn't really cut it. But then how do you build in that flexibility without leaving everyone vulnerable? Where's the balance?
That's where things get really interesting. It's all about implied terms, the art of a carefully crafted agreement. Finding that sweet spot between setting expectations and allowing for the unexpected, because let's face it, the unexpected always happens.
All right, you've piqued my curiosity. Can you give us a real-world example? Because right now, it all seems a bit theoretical.
Let's talk about the fisherman who got Alaska packered, a classic case. Really highlights what happens when someone tries to take advantage of a sudden power shift.
Ooh, I love a good legal thriller. Lay it on me.
Picture this. It's 1900, you're a fisherman, you've signed on to sail all the way to Alaska for the salmon season, right? You've got your contract, set amount for the season plus a bonus per fish. You arrive, start working, and then.
Wait, let me guess. They realize they've got the Alaska Packers Association right where they want them. It's not like those canneries have other fishermen just waiting around up there, right?
Exactly. They saw their opening and went for it, demanded more money, threatened to walk off the job unless the company caved.
Bold move. So, did the company give in?
They did. They were stuck. But here's where it gets interesting, when the fishermen get back to San Francisco.
Don't tell me the company refused to pay the extra cash.
Bingo. And here's the kicker. The court sided with the company.
Seriously. That seems a bit rough. What was the thinking there?
It all boils down to consideration, a fundamental contract law concept. Basically, both sides need to bring something new to the table when a contract is changed. In this case, those fishermen were already obligated to do the work for the agreed-upon price. Their threat to breach the contract. Not valid consideration. They weren't offering anything new for that higher pay.
So it's like trying to sell someone the same thing twice.
Precisely. The court saw right through it. The Alaska Packers case, a stark reminder that even when you think you've got the upper hand, trying to exploit a situation for a quick buck can backfire big time.
And a good reminder that courts, they're not just looking at the black and white of the law, they're thinking about fairness, about holding up the spirit of agreement.
It's true, courts really do look at the bigger picture. But, understanding these principles, it's not just about avoiding those pitfalls. It can actually give you an advantage when you're drafting or negotiating these relational contracts.
Okay, I'm all for having an advantage. So how does understanding these implied terms, like good faith, actually help someone in these agreements?
Let's dive into our second case, a bit of a journey into the world of big business. You ready for this?
I'm going to tackle that term everyone throws around. Best efforts.
All right, hit me with it. Best efforts. Let's do this. So the Ballantine beer case, this one, it shows how even a term like best efforts, you'd think it's straightforward, right?
Well, it can get really messy, especially when a company's trying to cut its losses.
Sounds like a story for this deep dive. I'm ready.
Picture this. Falstaff Brewing. They buy the rights to the Ballantine beer brand, right? Make some big changes. Marketing, distribution, the whole shebang. And sales? Well, they tank.
Ouch, yeah. That's not good. I bet the original Ballantine folks were not happy campers.
You'd be right about that. They sued Falstaff, claiming they didn't use their best efforts to keep the brand successful, just like their agreement said they should.
I mean, that makes sense. If you buy a brand, especially one with history, you kind of have this understanding that you'll at least try to, keep it afloat, right? Absolutely. But Falstaff, they argued, hey, we can run this brand however we see fit. We're losing money here.
Okay, so where's the line? What did the court say about this whole best efforts thing?
Big ruling, really significant. The court said best efforts, it's more than just hoping for the best, right? Falstaff, they had to prove they looked at other options, acted reasonably, not just take the easiest way out and ditch the Valentine brand altogether.
So even when things go south, you can't just throw in the towel, right? There's this expectation that you'll genuinely try to make it work, especially in these collaborative contracts.
Exactly. The Ballantine beer case, it shows best efforts, isn't just some vague idea. It's got teeth, provides that framework for accountability, making sure everyone's really putting in the work, even when things get tough.
This brings up a question for me, and maybe it's a bit nitty-gritty, but how do you actually prove something like best efforts in court? What kind of evidence are we talking about?
You're asking the right questions. That's the heart of it all. Really finding that balance, maintaining flexibility while setting those clear expectations. It's an art, for sure.
Walking a tightrope, it sounds like. So how do you manage that? What's the secret?
Think of it like building a house. You need a strong foundation, and that's where specific clauses come in, outlining the key parts of the relationship.
So we're talking things like termination rights if things go belly up, performance benchmarks, maybe even a system for handling disagreements before they blow up.
You got it. But then, on top of that foundation, you need those implied terms, the good faith, the best efforts. They fill in the gaps, you see. They give you a framework for figuring things out when those curveballs inevitably come your way.
Okay, starting to see the bigger picture now, but what about those times when things aren't written down? What if it's a handshake deal or a bunch of emails back and forth?
That, my friend, is where good documentation becomes your best friend. Even those informal agreements, those promises made in passing, they can have legal weight.
So always try to get it in writing, even if it feels a bit formal.
Ideally, yes. But if that's not possible, document, document, document. Keep track of those discussions and any decisions you both make, any tweaks to the agreement. Those records, they could be golden if things go south later on.
Like leaving a trail of breadcrumbs, just in case you need to find your way back.
Exactly. Protect yourself, make sure everyone's on the same page.
This is all incredibly helpful, I have to say. But if I'm being honest, I'm still a little wary of relying too much on implied terms.
Yeah.
It all just feels a bit, well, uncertain, you know. How can we really know what a court will consider good faith or best efforts in a specific situation?
I hear you. And it's true. There's always that element of uncertainty when you're dealing with legal interpretation. But that's where studying cases like the ones we've been talking about, that's where it gets really valuable.
So by looking at past rulings, we can kind of start to understand how courts have applied these concepts in the real world.
You got it. It's like getting a peek behind the curtain, you know.
Yeah.
You see how those abstract ideas play out in actual situations.
This deep dive is really eye-opening, I have to say. Never realized how much power these seemingly vague concepts actually hold.
It's all about understanding the nuances. And that, my friend, is where having some legal expertise in your corner can make a world of difference.
So if we're dealing with a particularly complex relational contract, one with high stakes, maybe it's time to call in the big guns, get a lawyer involved.
Absolutely. Having a legal expert on your team, someone who can navigate those complexities, draft solid agreements, and make sure your interests are protected, that's invaluable.
Couldn't agree more. This has been incredibly insightful. But before we wrap things up, I'm curious about the flip side of this. We've talked a lot about protecting ourselves using these implied terms strategically. But what happens when one party is genuinely struggling to hold up their end of the bargain?
Now you're getting to the heart of it. That's where things get really interesting, both legally and ethically.
This deep dive, I gotta say, it's been fascinating. We've gone from, like, fishing boats in Alaska to corporate boardrooms, all in what feels like, 15 minutes?
And you know what? We've only just scratched the surface. There's so much more to explore with these cases, these concepts. It's really incredible.
Really makes you think about all those agreements we make, right? Like how much complexity is hidden beneath the surface.
It's true. And that's what keeps things interesting, keeps it relevant, especially in today's business world. You know, things moving so fast.
So as we start to wrap things up here, what's the key takeaway? What do you really want our listener to walk away with today?
Don't be afraid to look beyond the words on the page. You know, think about the bigger picture, the relationship itself. Those implied terms, the good faith, the best efforts, they're powerful tools, not just about protecting yourself, but also about building those strong, lasting partnerships.
It's like recognizing that a contract, it's not just some static document, right? It's more like a framework, something to guide you through the ups and downs of any long-term agreement. And let's face it, there are always ups and downs.
Absolutely. And remember, this deep dive, it's been crafted with you in mind, based on the sources you brought to the table. So your own circumstances, the relationships you're navigating, they'll determine how these principles really play out in your world.
We've covered a lot of ground today, that's for sure. But before we go, we want to leave you with something to ponder, a final thought, if you will. We talked about the ethical side of things, right? Being flexible in those agreements. But what about those situations where there's a real power imbalance between the parties involved?
Now there's a critical consideration. Power dynamics, they can be tricky, subtle, even. And they can shift over time, especially in those long-term relationships.
So you're saying a contract that seems fair at the beginning could end up being incredibly one-sided later on if one side gains the upper hand, so to speak.
Exactly, and that brings up all sorts of questions, right? Fairness, the potential for someone to take advantage, even the limits of what the courts will actually enforce.
It really makes you wonder, at what point does a court step in and say, okay, this contract, on paper it's legal, but it's just not right. We're not enforcing this.
It's a question that's been debated for years, really. No easy answers there.
Yeah.
But it highlights something crucial.
Yeah.
We have to think beyond just the letter of the law. It's about fairness, ethical conduct, bringing those values into every deal you make.
That is some food for thought. And on that note, we want to hear from you. What are your thoughts on this ethical dilemma? Hit us up on social media. Let's keep this conversation going. And with that, thanks for joining us for this deep dive into the world of relational contracts. Until next time, happy contracting, everyone.